Heya Cryptozens, tonight's show. SEC's Hinman docs allowed in Ripple case. UK allows NFT lawsuit delivery. And Zac Prince says, don't compare BlockFi to Celsius. It's 10 p.m. and the date is July 13th, 2022. Welcome back to the Crypto Overnighter. My name is Nicodemus and I'll be your host. The cover model, mascot, and co-host for this podcast is Tex. And together we take a nightly look at the crypto, NFT, and metaverse space and the industry that surrounds it. So take a minute, go ahead and subscribe to the podcast now, because we're here at 10 p.m. every night so that when you leave in the morning, you're taking with you the crypto news analysis that you need to start your day. And keep in mind, nothing in this show should ever be considered financial advice. Hypocrisy, they called it. So today, the United States Securities and Exchange Commission, the SEC, experienced a bit of a legal setback because it was in their case against Ripple where the U.S. judge hearing the case accused the SEC of hypocrisy. In doing so, they denied the SEC's claims that the so-called Hinman speech should be protected under attorney-client privilege. And so it came to pass that in court proceedings, U.S. Magistrate Judge Sarah Netburn called out the SEC, accused them of hypocrisy, and her reason for doing so was based in the SEC's arguments. Now, William Hinman is a former director of the Division of Corporate Finance, and he held that position from May of 2017 to December of 2020. His former division's whole purpose in life is to make sure that potential investors are given the accurate information they need to make their decisions. They also provide some level of guidance to companies with respect to the SEC's rules, and they make recommendations to the SEC regarding new rules and existing rules. Now, it was during the period in 2018 that we're interested in. July of 2018, and former director Hinman was speaking at the Yahoo Finance All Markets Summit. Now, during this speech, Hinman said basically Ethereum isn't a security. It used to be, according to him, but it's not anymore. And his justification for this doesn't sit quite right with me. Okay, he said Bitcoin wasn't a security, and he said it was decentralized. And so that's why Bitcoin's not a security. Okay. And then he was talking about Ethereum, and he said Ethereum too is not a security. So despite having an initial coin offering, it went from being centralized, and thus a security, to decentralized and not a security. Now, there's an issue with this theory, and it's a big issue. It's based on a 1946 Supreme Court case, because it was in 1946 that the Supreme Court handed down the Howey test. The Howey test is used to determine if something is an investment contract or not, and thus a security or not. Now, depending on how you break it down, I have read the Howey test between 2 and 4 parts. So let's look at the 4-part interpretation. If you can answer yes to these 4 questions, you've probably got yourself an investment contract. This is not legal or financial advice, by the way. These 4 questions are you investing money? Are you investing that money in a common enterprise? Are you expecting a profit from your investment? And if so, is that profit coming from the efforts of others? Did you notice something missing? Yeah, there's no room in the Howey test based on how decentralized something is or isn't. But none of that really matters for this case. What matters for this case, and for this ruling, today's ruling, is that you have a senior official from the Securities and Exchange Commission giving a speech. So he should be considered an expert on what a security is. What's important here is that Hinman gave his expert opinion and said that Bitcoin and Ethereum were not securities. The SEC would rather everyone just forget about that speech. The SEC has been fighting to keep the draft of that speech under wraps because it was in late 2020 that the SEC decided to sue Ripple on allegations that the XRP token is an unregistered security. Judge Netburn was not gentle. In fact, quite the opposite. She said, quote, "The hypocrisy in arguing to the court, on the one hand, that speech is not relevant to the market's understanding of how or whether the SEC will regulate cryptocurrency, and on the other hand, that Hinman sought and obtained legal advice from SEC counsel in drafting his speech, suggests that the SEC is adopting its litigation positions to further its desired goal and not out of a faithful allegiance to the law. So, not a good day for the SEC. These documents could make a huge difference in the case. That said, this might well not stand. Now, the SEC is saying that this speech has no bearing, that it was just a, quote, purely personal errand. I say that's balderdash. When I go to work at the fiat mines, I work for the government. Any single thing I produce belongs to my employer. If I write a paper, if I create an app, if I discover anti-gravity, if I used my employer's time and resources to do so, they own it. Not me, they own it. And further, he is an employee of the United States government. So that means each citizen can lay claim to his work because we as taxpayers paid for his time to create that speech. So there's that whole FOIA aspect to the case as well. Personally, I think the SEC loses this round. I think the judge offers no extensions. The SEC appeals. The SEC loses case. Case moves forward. That's just my speculation, though. Kind of a wild ride on the markets today. It dropped heavily on news of 9.1 CPI, but the market made up ground and then some. At the time of writing, the global crypto market cap is $899 billion. It's up 4.07% in 24. The top 5 cryptos by market cap are Bitcoin up 4.26%, Ethereum up 6.34%, Tether, USDC, and Binance Coin up 4.64%. Okay, imagine this. You go to OpenSea. You're thinking about buying a couple of NFTs, and I know what I do. First thing I do when I buy an NFT on OpenSea, I go to my profile to admire it. I click on profile, and I can just see it sitting there in all its glory. Then I noticed a new NFT in my wallet. The name should have been given away. Opening it up, one thing is for certain, you have been served. This isn't theory. This isn't wouldn't it be cool or wouldn't it be horrible. This is reality. GM Brown and Partners are a UK law firm, and they filed for a lawsuit. This case has been brought by Fabrizio Di Olia against Binance, Poloniex, Gate.io, OKX, and BitCub. The claim is that someone was operating a clone online brokerage, and that's where someone pretends to be an FCA-authorized firm when they're not. The details of this particular suit are mostly irrelevant, at least for our purposes tonight. What's interesting about this case is that a judge allowed the parties to be served via NFT. That's right, airdrop. They got the worst kind of airdrop, a court summons, which I have my concerns about, but let's continue. So they dropped an NFT summons into the wallets that Diolia held but were stolen from him. So there's a precedent in UK law for this kind of thing. The civil procedure rules allow lawsuits to be served in a number of ways. Personal services, the mail, dropped off at a physical address, faxes, even a contact form. Yeah, they used a contact form on a website to get someone a summons. And Facebook messages, Instagram IMs. So they've done it a number of ways. This is different, though, because in those cases, it's usually done where both parties agree on that kind of delivery. Either that or a court decides that they have good reason to do so. That seems to be what happened here. So that and the exchanges were also informed not to let any money move out of or get withdrawn from or transferred out of those accounts. Giambrone Law tweeted out, quote, "Our firm was the first law firm in the UK and in Europe to obtain permission by a high court judge to serve document proceedings related to a worldwide freezing injunction against unknown persons by NFT using the blockchain technology." I do not think this is a good idea. Here's why. You don't know what's been dropped on your wallet. I covered a scam a while back, and the scammers would drop their garbage on someone's wallet, like Vitalik or Elon. And then they'd use that as alleged evidence that their project was legit. It's got to be legit. Look at Elon's wallet. It's right there, and he has some. And he's smart. That's their scam. Thing is, Elon didn't even know that was dropped in his wallet. Same thing with NFTs. I went to my hidden folder one time, and I found a number of NFTs in there. Also scammy, derivatives and clones of other people's projects. I had no idea they were even in there. So it would really suck to get served and not even know it. Then you get arrested for not showing up for a court date you didn't even know you had. Now, so far, this has only been used in cases where the target's identity is unknown. But I can see it being expanded. Look at the situation with the Three Arrows Capital guys. You can't find them. So maybe they drop a couple of NFT summons on Suzu and Kyle Davies' wallets. Not that I feel bad for Suzu Davies. I don't, but it's a really bad, ugly precedent to set. And folks in the United States should be wary. A U.S. judge allowed a temporary restraining order to be dropped as an NFT on an unidentified party's hot wallet. So precedent has been set. I just hope they're smart enough to keep it under control. The global NFT market cap is up 3.49%. Sales volume is down 1.89% in 24 hours. According to CoinMarketCap, the top 5 NFT collections by sales volume are CryptoPunks, followed by Bored Apes, Otherdeed, Mutant Apes, and the Saudis. Now keep in mind, some of these collections have very volatile prices, so do your own research. Zac Prince is CEO of BlockFi. He is also not a fan of comparisons between BlockFi and crypto companies that have been struggling of late, like Celsius and Voyager. At the heart of it is the private shares fund. He was on a July 9th article on Bloomberg, and the title was BlockFi Investor Prepared for Heavy Losses as FTX Forged Deal. And that might have been the nicest thing that they said about BlockFi in the whole article, because it wasn't too far into the article that they said, quote, the private shares fund, a fund overseen by Liberty Street Advisors, marked down BlockFi's warrants as worthless in the fund report at the end of June. Now, if you're wondering what these warrants are, here you go. They're derivatives that give the right to equity to BlockFi investors. And they said those warrants are worth zero, which means they don't see much value in the future equity of BlockFi. And so it came to pass that Prince wrote a short Twitter thread. It's a couple of tweets, so I'll just read it out. PSA to journalists and market commentators, it's time to stop putting BlockFi in the same bucket/sentence as Voyager and Celsius. 2 months ago, we looked the same. They shut down and have impending losses for their clients. BlockFi is fully functional across all products, credit card, loans, trading, earning interest, no client losses, raised interest rates in July, and we have exciting stuff in the pipeline. So his argument is we're working and they're not, so we're not the same. But that wasn't the only source of that kind of comparison. Pantera Capital put out their blockchain letter entitled DeFi Worked Great. It's a breakdown of the performance of centralized finance versus decentralized finance in the recent crisis. The way the authors put it, they're fighting a misconception. And the misconception that they're fighting is that DeFi failed. Pantera doesn't see it that way at all. They offer this as a rebuttal to a Wall Street article entitled DeFi Has an Existential Problem. The Pantera authors wrote, quote, decentralized finance protocols like Aave, Compound, Uniswap, MakerDAO all functioned flawlessly 24/7. The crisis proves the opposite of the common narrative. It proves DeFi works great, way better than centralized finance firms like Celsius, BlockFi, Lehman Brothers, et al. So DeFi doesn't want to identify as centralized finance because of the massive galaxy-shaking failures lately. And BlockFi doesn't want to be identified with central finance. So as he does, Zac Prince took to Twitter. He thinks that the comparisons are inaccurate and misleading. He feels like lumping BlockFi in with failed firms is just gross. And now he took some time to explain a few things. He points out that Anchor was total DeFi. Also points out that it's inaccurate to say that all DeFi protocols succeeded, as it's inaccurate to say all centralized programs were successful. He said, quote, "Putting BlockFi alongside Celsius and Lehman Brothers in the same sentence is misleading. They are or were bankrupt or insolvent. We are not. I would appreciate you editing this if you're open to being more accurate with your writing." And there are comparisons, and some of these comparisons are fair. BlockFi found itself in trouble just as much as Celsius and Voyager did. BlockFi accepted a bailout from FTX just as Voyager did. The fact is, neither DeFi nor centralized finance performed flawless. Both groups had substantial failures. Both groups had great successes. Maybe DeFi and CeFi need to stop fighting and start figuring out whatever the other side was doing right. And that's going to do it for us tonight. I want to thank you, my listeners, because when you stop listening, I'll stop talking. You stay safe out there. Watch out for yourselves, but watch out for each other too. We'll see you tomorrow night.